and the historic ruling in the civil fraud trial against former President Donald Trump. A judge ordered Trump to pay more than $350 million in penalties and barred him from serving as an officer or director of any New York company for 3 years. Today's decision comes months after he was found liable for falsifying business records in order to get better terms on loans and insurance. It is a major victory for New York State Attorney General Letitia James, who first sued the former president back in 2022. Well, tonight, Trump called the ruling, quote, a total sham. CBS's Robert Costa has the details from Lower Manhattan.
Well, thank you very much.
Tonight, a potentially crushing blow to Donald Trump's business empire and bank account. The former president ordered to pay more than $350 million and banned from running a business in New York or applying for loans in the state for 3 years. His 2 sons each fined $4 million and barred from doing business in New York for 2 years, thrusting the leadership of the family company into peril.
What's happening, friends? Welcome to Jack Mockler Right Now. For decades, Trump built a portrait of himself as a self-made titan who transformed an inheritance into a global empire, with buildings and golf courses bearing his name. That story propelled him from the boardroom to the presidency, but the foundation of that carefully constructed image is now under scrutiny. A New York judge has found shocking, systematic, years-long fraud in Trump's financial statements, exposing the numbers behind the empire he built, the asset valuations and net worth claims he presented to banks and investors. The ruling's consequences extend far beyond financial penalties, reaching into the very structure of the business empire that has been the foundation of his public identity for decades.
Being prohibited from doing business in your home state or the state where you have so many properties and so many business activities is an absolutely devastating sanction.
Trump lawyer Alina Habba called the verdict a manifest injustice and said an appeal battle is coming. The former president reacted late today.
It's a very sad day for, in my opinion, the country. A New York State judge just ruled, and he's crooked as you could get. And a lot of people expected something like this, but not for the amount.
In his ruling, Judge Arthur Engoron said of Trump and the other defendants, their complete lack of remorse borders on pathological.
This whole thing is very unfair.
On Trump himself, who took the stand 2 times, the judge said his refusal to answer the questions directly, or in some cases at all, severely compromised his credibility. Judge Engoron had already ruled that Trump and his sons and company executives committed years of business fraud, fraudulently inflating their assets to boost the former president's net worth, including his Trump Tower penthouse and Mar-a-Lago, exaggerating its value by as much as 2,300%.
Thank you very much.
Today's penalty caps a 3-month trial in a lawsuit brought by New York Attorney General Letitia James.
The scale and the scope.
The judgment that landed from Judge Arthur Engoron's courtroom was not merely a legal document. It was an earthquake that sent shockwaves through the political and financial worlds, a reckoning that commentators reached for words like catastrophic and devastating to describe. The former president and his co-defendants were ordered to pay more than $350 million in civil penalties, a figure that alone would be devastating for most businesses. But the ruling went much further. It revoked key business certificates that Trump entities relied upon to operate in New York. It imposed a 3-year ban on Trump personally running any company in the state. It raised the specter of court-appointed oversight of his most valuable assets, including the flagship properties that define his brand.
Tonight, a crushing blow to the Trump family's real estate empire. A judge in New York handing down a more than $350 million civil penalty against Donald Trump, plus interest, for lying about his wealth for financial gain, barring him from obtaining loans in the state for 3 years, banning Mr. Trump's adult sons from running any company for 2 years, ordering they pay more than $4 million each.
Today, justice has been served. Today, we prove that no one is above the law.
The former president tonight assailing the decision and slamming the suit brought by New York's Democratic Attorney General.
These are radical left Democrats. They're lunatics. And it's election interfering. If I weren't running, none of this stuff would have ever happened.
With no jury at trial, today's ruling left solely in the hands of Judge Arthur Engoron, who decided the heart of the state's fraud case months ago, finding the Trump family wrongly exaggerated the value of some of its most iconic properties on financial statements to receive better deals on bank loans. This trial was to sort out the penalty. Mr. Trump and his adult children all took the witness stand in the hopes of fending off a decision with massive consequences for their real estate portfolio.
And it opened the door to a process that experts described in terms that would have been unthinkable even a few years ago: the potential forced liquidation of the very empire Trump has spent decades constructing. The Attorney General who brought the case, Letitia James, had argued that Trump should be banned from doing business in New York entirely. And while the judge did not go quite that far, the remedies he imposed achieved much of the same practical effect. Trump had denied wrongdoing throughout the trial, repeatedly characterizing the proceedings as a politically motivated conspiracy designed to damage him. But the court's findings were based on documentary evidence, not political rhetoric, and the ruling that emerged was devastating.
And family legacy.
I became president because of the brand.
Mr. Trump's defense team arguing there was no victim, the banks were repaid, and testified they did not rely on Mr. Trump's valuations. The former president's attorneys had implored the judge not to impose a fine akin to the corporate death penalty. But today, the judge writing, quote, "Donald Trump is not Bernie Madoff," yet defendants are incapable of admitting the error of their ways. Instead, they adopt a see no evil, hear no evil, speak no evil posture that the evidence belies.
And Laura, this isn't over yet. The Trump team says it will appeal. What's that look like?
That's right, Lester. But if that appeal should fail, Mr. Trump is facing not only a massive penalty here, but the number itself could balloon with all of the interest involved. A real question for this company: will it be forced to sell off some of Mr. Trump's most prized assets to pay for this judgment, Lester?
The specific findings about the scope and scale of the fraud detailed how Trump and his organization systematically inflated the values of properties and their overall net worth on financial statements used to obtain favorable loan terms. This was not a minor accounting dispute or a technical question about appraisal methodology. It was a finding that the numbers Trump presented to banks, the numbers that established his credibility as a financial titan, were deliberately and systematically misrepresented. To truly grasp why this ruling landed with the force of a wrecking ball, you have to understand what it actually established and how far its reach extends. The court found that Trump's organization had engaged in a pattern of fraudulent behavior that was not marginal or accidental, but systematic and intentional. The inflation of asset values was described by the judge using language that judges employ sparingly, knowing that their words carry weight in the permanent legal record. He used the word shocking, and when a judge characterizes financial conduct in those terms, it signals something profound about the nature of what was discovered. The inflated values were not rounding errors or differences of opinion about complex real estate appraisals. They were substantial misrepresentations that banks relied upon when deciding to extend credit to Trump entities on favorable terms. Those banks were under the impression they were lending to a borrower whose financial position was far stronger than the evidence now shows it actually was. The fraud was not victimless. It distorted the lending decisions of financial institutions, potentially exposing them to losses they would not have incurred if the true financial picture had been disclosed. And it allowed Trump to present himself to the public and to business partners as a far wealthier figure than the actual financial reality supported. The consequences for those banks are still unfolding as they reassess their lending relationships and consider whether they have legal recourse against Trump entities for the misrepresentations they relied upon. But the immediate consequences for Trump's business operations are the most dramatic and the most visible. Judge Engoron's ruling described Trump's lack of remorse as bordering on pathological, unusually strong language from a civil fraud opinion, reflecting the judge's assessment that Trump could not be trusted to operate honestly without significant constraints. Combined with the E. Jean Carroll defamation judgment, the total exposure exceeded $400 million plus interest, creating an existential burden that even for Trump's claimed wealth represents a business-ending threat. The specific problem was not just the size of the number, but what it revealed about the relationship between that number and Trump's actual financial position. For years, Trump had made claims about his personal wealth and personal cash reserves that the fraud trial put under sustained scrutiny. If those claims were inflated and the court found that the financial statements supporting them were fraudulent, then the actual cash available to satisfy the judgments might be far less than Trump's public persona suggested. That gap between the claimed wealth and the real financial position is exactly the kind of thing lenders pay very close attention to when deciding whether to continue extending credit to a borrower who is suddenly facing hundreds of millions of dollars in civil liability. And the lenders were paying very close attention indeed. The prospect of court-appointed receivers taking control of Trump Organization assets, of the buildings and the golf courses and the hotels that carry his name being placed under the oversight of individuals appointed by the court rather than controlled by Trump himself, was the specific element of the ruling that experts described in the most dramatic terms. The falling dominoes image that legal analysts reached for was not rhetorical excess. It was a specific description of how asset liquidation works when court-mandated receivers take control, a process that can accelerate in ways that are difficult to reverse once it begins. Individual assets are sold to satisfy judgments, and the revenue they generate is no longer available to service the remaining debt on the properties that have not yet been sold. The Trump Organization's business model depends on the continued existence and continued profitability of the empire as a whole, on the brand value that comes from operating a portfolio of high-profile properties rather than a shrinking collection of assets being sold off under court supervision. Once that model starts to unwind, the unwinding creates its own momentum in ways that are genuinely difficult to stop, and that momentum is now beginning to build. Let's take a moment to examine the specific legal and financial mechanisms that the fraud ruling has set in motion, because understanding these details is essential to grasping why the consequences are as serious as the most dramatic coverage suggests. The full picture requires understanding how the specific remedies imposed by the court interact with the existing financial structure of Trump's business operation to create a situation that is qualitatively different from any previous legal or financial challenge Trump has faced. The full revocation of business certificates for Trump entities operating in New York is not a symbolic penalty or a reputational slap. It is a practical operational consequence that affects the ability of those entities to conduct ordinary business in the state of New York, to enter into new contracts, to manage existing properties, to maintain the relationships with vendors and partners and lenders that any ongoing business requires. New York is not a peripheral location for Trump's business empire. It is the center of it, the state where the most valuable and most famous properties are located, where the financial relationships that support the entire operation are based, and where the brand value associated with Trump's name is most concentrated and most dependent on the continued operational legitimacy of the entities that carry it. Removing the business certificates of those entities creates a legal cloud over their operations that has immediate and practical consequences for everyone who does business with them. Banks become more cautious about extending credit. Vendors become more careful about extending terms. Partners become more hesitant about entering into new arrangements. The operational friction created by the certificate revocations slows down business activity, increases costs, and makes it harder to generate the revenue needed to service existing debt and maintain the portfolio of properties that constitute the empire. The 3-year ban on Trump personally running New York businesses is a remedy that addresses the specific risk that the court identified in the conduct it found fraudulent. The risk that the same person who supervised the systematic inflation of asset values will continue in a position of control where similar conduct is possible in the future. Courts impose this kind of exclusion from business management not as additional punishment, but as a specific forward-looking remedy designed to prevent the recurrence of the conduct that was found to be fraudulent. The imposition of that ban on Trump specifically not just on the organizations he runs but on his personal ability to manage them, is a direct and personal consequence of the court's conclusion about his role in and responsibility for the fraudulent conduct. It means that for 3 years, Trump cannot personally make the management decisions about his New York business operations that he has been making for decades. He cannot be the decision maker in the room. He cannot be the one who signs off on the financial statements or negotiates the loan terms or decides which properties to develop and which to hold. That restriction, for someone whose business identity and personal identity are as thoroughly intertwined as Trump's are, is not just a legal sanction. It is an identity-level intervention that fundamentally changes the relationship between Trump and the empire he built. The court monitors overseeing Trump Organization assets add another layer of constraint that has immediate operational implications. When a court appoints monitors to oversee business operations, those monitors have access to the financial records, the business decisions, and the operational details of the entities they oversee. They report to the court. They can raise concerns about conduct that they observe. They create a layer of scrutiny and oversight that makes it significantly harder to engage in the kind of financial maneuvering that the court found fraudulent in the past. The presence of court-appointed monitors is not just a symbolic demonstration of judicial oversight. It is a practical mechanism that changes the information environment within which the business operates, creating a permanent record of decisions and a permanent point of accountability to the court that did not exist before the ruling. The broader financial consequences of the combined civil judgments extend beyond the Trump Organization itself and into the personal financial situation of Donald Trump as an individual. And the implications of that personal financial exposure are among the most politically significant aspects of the entire situation. For years, Trump's political brand has been built in significant measure on the image of extraordinary personal wealth, of a man who is so rich that he cannot be bought, so successful that his business judgment deserves deference, so independent that he owes nothing to the donors and the special interests that he argues have corrupted ordinary politicians. That image has always rested on the financial statements that the fraud court found to be inflated. If the actual financial reality is significantly different from what those statements claim, and the court's finding that the statements were fraudulent creates that specific inference, then the political brand built on those statements rests on a foundation that has been judicially determined to be false. That is not just a legal problem for Trump's businesses. It is a political problem for Trump's persona. The man who claimed to be so wealthy that he could not be corrupted has been found by a court to have built that claimed wealth on systematic misrepresentation. The political implications of that finding have not been fully worked through, but they are real and they are significant. Voters who based their support on the belief that Trump was a successful businessman who could bring that success to government are now confronted with a judicial determination that the business success itself was built on fraud. That determination does not automatically change political allegiances, but it creates a cognitive dissonance that campaigns find difficult to manage and that opponents will exploit relentlessly. The way that banks and financial institutions that have historically provided the credit that Trump's business operation depends on have reassessed their relationships with him in the wake of the judgment is one of the most consequential and least publicly visible dimensions of the entire story. Banks do not typically publicize their lending decisions or their assessments of specific borrowers' creditworthiness. But the signals that have emerged from the financial community in the aftermath of the fraud ruling suggest that the judgment has materially changed the calculations that major lenders are making about the risk profile of Trump-related borrowing. A borrower who has been found by a court to have submitted fraudulent financial statements to obtain loans is by definition a different credit risk than a borrower who has not. The specific finding that the financial statements were inflated, that the numbers Trump presented to banks in support of loan applications did not accurately reflect the actual value of assets being offered as collateral, raises direct questions about the validity of loan agreements that were entered into on the basis of those statements. That is not an abstract legal concern. It is a concrete business problem with immediate practical consequences for any business that depends on continued access to credit. Lenders are now asking themselves whether they can continue to extend credit to an entity whose financial statements have been found fraudulent, whether they can rely on the valuations that Trump entities present, and whether they want to be associated with a borrower whose legal and financial troubles have become so public and so damaging. The answers to those questions are not favorable to Trump's business operations, and the credit constraints that result from those answers will make it harder for the empire to continue operating as it has. The question of what happens if the appeals process does not produce a reversal, if the New York fraud judgment is upheld through the appellate process and the remedies imposed by Engoron ultimately enforced, is one that the people who have studied Trump's financial situation most carefully have answered in terms that range from serious to existential. The combination of the financial judgments, the business certificate revocations, the personal management ban, and the court oversight represents a layered set of constraints that apply simultaneously to a business operation that was already described in some reporting as heavily leveraged and dependent on the political brand for its ongoing viability. These constraints could produce the kind of cascading consequences that the falling dominoes image was designed to capture, not necessarily overnight, as the legal process involves appeals and stays and procedural steps that take time, but potentially inexorably, with each step in the appeals process being another point where the judgment can be affirmed and the remedies move closer to full enforcement. The timeline for that cascade playing out fully is measured in months and years rather than hours, but the direction of the cascade once it begins is difficult to reverse, and the ruling that set it in motion has been issued. The order has been signed. The nightmare for the empire Trump built his entire public identity around is not a threat anymore. It is the current legal reality, and the question of how far the fallen dominoes will go before the appeals process catches up with them is the question that will shape the Trump business story for years to come. What does all of this mean for the larger picture of Trump's legal and financial situation, and how should we think about the relationship between the court's findings and the political and business reality that Trump navigates every day? The first thing to understand is that the fraud ruling represents something qualitatively different from the criminal cases and the other civil litigation that has surrounded Trump over the past several years. The criminal cases are about potential incarceration, about the ultimate personal liberty consequence of the legal system. The civil fraud case is about the business empire itself, about the specific assets and entities and financial relationships that constitute the material foundation of Trump's public identity and political power. When a court reaches into the business empire and revokes certificates and imposes oversight and bans management and orders massive financial penalties, it is doing something that has a different and, in some ways, more immediate practical impact than the criminal proceedings. The criminal cases, even when they result in conviction, can be processed through the political and legal system in ways that delay and sometimes indefinitely postpone the most severe consequences. The civil fraud judgment works differently. It imposes consequences that attach directly to the businesses and their ability to operate in ways that do not require the same kind of prolonged institutional processing. The judgment is final and enforceable, subject only to the appeals process, and the remedies it imposes begin to take effect immediately, creating operational constraints that cannot be ignored or postponed. The second thing to understand is what the fraud ruling reveals about the specific vulnerability of a business model that is built as heavily on brand value and personal reputation as Trump's has always been. Most businesses have an underlying economic value that is independent of the reputation of the person who runs them, the value of the assets, the cash flows they generate, the market position they occupy. Trump's business model has always been unusually dependent on the personal brand, on the specific associations that the Trump name carries, and on the willingness of partners, lenders, licensing clients, and customers to pay premium prices for access to those associations. That model generates significant value when the brand is strong, But it also creates significant vulnerability when the brand is damaged, because the premium that the brand commands collapses faster and more completely than the underlying asset value would alone. When a court finds formally and publicly that the financial statements supporting the brand's claims of extraordinary wealth were fraudulent, it does not just damage the legal position of the entities involved, it damages the brand itself, the specific associations that justify the premium. That damage is real, and it is durable in ways that are difficult to repair, even if the legal appeals ultimately produce some modification of the judgment. The brand premium that Trump has relied upon for decades is now subject to a court finding that the foundation of that premium was built on misrepresentation. The partners who paid premium prices for licensing deals, the customers who paid premium prices for hotel rooms and golf memberships, the lenders who extended credit on favorable terms based on the claimed wealth, all of those parties are now reassessing whether the Trump name commands the same value it once did. And the answer to that question is increasingly becoming no. The third and perhaps most significant thing to understand is what the combination of the fraud ruling and the other legal proceedings tells us about the long-term trajectory of Trump's business operation and its relationship to his political career. Trump's political power and his business power have always been deeply intertwined. His political brand has sustained and enhanced his business brand, and his business brand has provided the foundation for his political identity as a successful outsider who owes nothing to anyone. The legal proceedings of the past several years have been systematically damaging both. The criminal convictions damaged the political brand by establishing a permanent record of judicial findings against him. The fraud judgment damages the business brand by establishing a permanent record of judicial findings that the financial statements he used to build his reputation as a business titan were systematically inflated. Together, these proceedings are eroding both the political foundation and the business foundation of the entire Trump enterprise in ways that are cumulative and mutually reinforcing. The erosion of one weakens the other because the two have always been mutually dependent. The political brand depends on the credibility of the business success story, and the business brand depends on the political support that has sustained Trump through various controversies and legal challenges. As both erode simultaneously, the combined effect is greater than the sum of its parts, creating a downward spiral that becomes increasingly difficult to arrest. The fraud ruling does not just impose legal consequences, it examines the factual foundation of Trump's business success claim and finds it wanting, changing the foundational argument of his political identity that wealth proved his judgment. The falling dominoes cascade from the judgment itself to lender reassessments and narrowed financial flexibility could erode the empire in ways that no amount of political rhetoric can fully repair. The court's finding of shocking, systematic, years-long fraud in Trump's financial statements has set off a cascade of consequences, legal, financial, and reputational, that will erode the empire he built his identity around. Each consequence makes the next more likely and more severe, with the damage extending to employees, partners, investors, and the brand premium that sustained the entire operation. The empire may survive, but in a diminished form, stripped of the mythology that made it seem larger than life, with the legal record of fraud following Trump for the rest of his business career.